Welcome to Elder Savvy. I'm Mary Willis, the Director of the Pembroke Council on Aging. Our guest today is Attorney Pat Stewart, and she's going to tell us a little bit about herself, and then we'll go into the question 2, the ballot question on the election. So tell us about yourself, Pat.
Well, I'm happy to, Mary. Thank you for having me today. I'm born and raised in North Attleboro, Massachusetts. I've been an attorney for 34 years in the Commonwealth. Most of that time I was a trial lawyer, almost 25 years, in the area of aviation law, in which I represented people who'd been injured in aircraft accidents. And when I decided I had enough of trial work, I turned my attention to the field of healthcare and wrote a little book that teaches people how to make healthcare choices that protect life. I do public speaking on that and teaching about that now. And because of that work, I was asked to get involved with the group that is opposing Question 2 on the ballot this November. The Massachusetts Against Doctor-Prescribed Suicide is a group of doctors, lawyers, healthcare workers from the palliative and hospice communities, and members of the disability community who have been doing voter education on this important ballot question.
Very interesting. So now tell us what you've learned about question 2.
Well, question 2 is titled the Death with Dignity Act. It is an attempt to make it legal for doctors to write prescriptions for lethal drugs at the request of a terminally ill patient in order for that patient to commit suicide. This proposal is sponsored by a group which calls itself Compassion and Choice. They are formally known as the Hemlock Society, and our objective is to make doctor-prescribed suicide simply just another medical treatment option. The problem with this proposal, however, is that it is extremely poorly written, it is confusing, and it lacks essential, adequate safeguards for the public. And for that reason, I have been out talking to people, pointing out to them where I see deficiencies in this statute, and raising concerns about how it would actually work if it became law in Massachusetts.
I see. So continue on.
Okay, well, I'll tell you how this proposal would work in practice. A patient who has been given a diagnosis as having a terminal illness would make a verbal request to their doctor for this prescription, and at the same time would also sign a form indicating they want to take advantage of this prescription for the lethal drug. They then would have to wait 15 days, and at that point renew the verbal request and telling the doctor, yes, I'm still interested in having this. The doctor would then write the prescription and then give it to the patient or the patient's representative. It would be filled at a pharmacy. And that's as far as the statute goes with any provisions for how this process will be completed. And that's, in very brief form, what is written. However, the proposal itself is actually 10 pages long. It's condensed into about 6 or 6.5 pages in the voter information book, which I encourage people to read, although I recognize that it's even less readable than it was in the 10-page format because the text is all scrunched together and it's even smaller typeface. So what I am attempting to do with my discussion is to highlight for people some of the features and aspects of this proposal that are, I believe, cause for concern. And one of them is the criterion that are used by which a patient becomes eligible to make this request. And the first is that that patient is considered to have a terminal illness. Now, the statute defines terminal as irreversible and incurable, and a disease that will cause death within 6 months. Now, notice that it doesn't say the disease is untreatable. And what that means is that someone who has a disease or an illness that requires that person to take medication on a regular basis, for example, someone with diabetes who is dependent on insulin, if that person stops taking their insulin, they may well die within 6 months and therefore would be considered terminal for purposes of this proposal. If they continue taking their insulin, they might well live a very normal life expectancy. So the significance is that this proposal as written enlarges vastly the scope of potential people who might become eligible to take advantage of this lethal prescription. Secondly, in the diagnosis of, or prognosis, I should say, of a 6-month life expectancy is very much a lot of guesswork in terms of what doctors can do in predicting lifespans with illness. And doctors readily admit this, that many times they get it wrong. And I've talked with a number of people who have acknowledged they know people who were given these very short life expectancy prognoses and lived far beyond the time that they were told they would live. And further evidence of how imprecise these forecasts are comes from the Oregon Public Health Department, which is, Oregon is one of the 2 states where this doctor-prescribed suicide has been made law. And it's the exact law that is being proposed in Massachusetts, as has been in effect in Oregon and Washington. In Oregon, the Public Health Department reported that for the period of 2008 to 2011, the time between which a patient requested that the drug until the patient died varied from 15 to 1,009 days. That's almost 3 years. So you can see by documented records how far off these prognoses can be. And lastly, another problem with the term of terminal illness is the fact that abuses have been reported in both Oregon and Washington. And among those is the fact that sometimes people are just completely misdiagnosed. Those people who have a severe illness, who are disabled, have been diagnosed as terminally ill, when in fact they were not. And the consequence of that is that you put people in a state of mind, perhaps, of panic, of hopelessness, when they might avail themselves of this prescription, end their lives prematurely, when in fact they were not terminally ill at all. So that's just one example of the way the proposal is written that creates a whole host of problems and confusing situations. Another area of where there's a problem with the terminology in this statute is that it speaks that to a requirement that a person requesting this prescription must be an adult with the capacity to make and communicate their own healthcare decisions. And by capacity, they mean that the person does not have impaired judgment. However, there's no requirement for any kind of psychiatric or mental health evaluation of the patient at the time that they make this request. And this is significant because many studies have shown that most of the time when people think about suicide, it's because they are depressed. And depression is a treatable illness if it's picked up. But without a professional, expert intervention of a psychologist, a competent psychologist who has knowledge about mental health issues, this person can slip through and end up getting this prescription instead of getting adequate mental health intervention. In fact, again, we can look at the record in Oregon, and for the 3 years between 2008 and 2011, they report that only 2% of patients were referred for psychiatric evaluation when they made these requests. Now, how can that be when most of the time people request this because they are depressed? So you can see that if it's not required, most of the time that psychiatric or psychological intervention is not going to be ordered, and there are many people who are going to slip through, again, the process who should not be taking advantage of this prescription and ending their lives. The other piece of adult capacity and ability to communicate, to make show no impaired judgment, that you can make the decision, but you also have to be able to communicate the decision. And that's fine, except that the statute provides that the communication can be made by someone on behalf of the patient who's familiar with the patient's manner of communicating. For example, a patient who does not speak English, could have an interpreter make that request for them. However, it could also apply to a patient who communicates non-verbally. Perhaps that person has paralysis and communicates with eye blinks. Someone could come in and indicate that they're interpreting those eye blinks by the patient to mean that they are requesting the doctor prescribe suicide. But there's no requirement for that interpreter to demonstrate expertise or experience in working with this patient to show a basis upon which we can rely to show that this person's interpretations are accurate. And there's no requirement for the interpreter to show that they're not interested in having this patient die because they stand to benefit in some way by the patient's death. For example, an heir who's expecting to inherit something at the time of the patient's death. So again, these are areas of a potential concern and abuse in the way the statute is proposed. The last point I would make about the terms of the way this proposal is written, and there are many beyond those which I'm highlighting, but just in the interest of time, I've picked out 3 that are pretty dramatic. And they have to do with the eligibility of the patient to make this request. Besides that they begin to have a terminal illness and they have the capacity to an unimpaired judgment to make a decision for themselves, they have to be acting voluntarily. Now that's a good thing. We want people not to be feeling compelled to do this by someone else. But the form that the patient has to sign, which I mentioned earlier, has to be signed to put their request in writing, completely undermines the requirement of the voluntariness on the part of the patient. And here's why. The form has to be signed by the patient in the presence of 2 witnesses. Only one of those witnesses has to be what we call disinterested, meaning that the witness is not going to inherit or benefit in some way by the patient's death and is not related to the patient by blood, marriage, or adoption. The other witness, however, can be related to the patient by blood, marriage, or adoption and may well be an heir or someone who will inherit from the patient's estate at the time of the patient's death. The significance of this is important when you compare it to what the rules are when a person in Massachusetts signs a will. When you sign a will, you have to do so before 2 disinterested witnesses. And the purpose for a witness is to attest to the fact that they're observing this person sign the will and that they appear to be of sound mind, under no constraint or undue influence. And when the witnesses are completely disinterested and have nothing to gain by lying about those observations, we can have greater confidence that what the witness has attested to is true. Now, if the doctor prescribed suicide provision were to become law in Massachusetts, the result would be that you would need 2 disinterested witnesses to dispose of your property, but only 1 to dispose of your life. And I ask that you potential voters consider, is this really an adequate safeguard? Is this really all the protection that people need at this critical point in their lives when they're thinking about ending their lives? So those are just 3 of the provisions in the statute as written. But unfortunately, that's where the statute stops treating of anything to do with the patient. It completely abandons the patient at the most critical point, which is when the patient ends his or her life. And what the statute doesn't say is as important as what it does say. There are a few points which I could touch on there, but I don't know if you have any other questions about what I've just spoken to.
Well, I've heard rumors and read articles on what you have spoken to, and it's an insurance company issue where insurance companies will say that we could open the door to them saying that we can't afford to treat your illness, so you have a choice die a natural death without treatment or take the assisted suicide medication.
Well, that's correct. That's a definite concern with this way this proposal is written. A lot of the supporters talk about it being about a question of choice. And in fact, it's a choice that most probably will result in being the choice of insurers. And here's why. In Massachusetts, we all know, and in elsewhere, financial pressure is a reality in healthcare today, pressure to cut costs. And just this past August, Governor Patrick in Massachusetts signed the Healthcare Cost Containment Law. And that law proposes to cut $200 billion from healthcare costs in Massachusetts over the next 15 years. That's more than $15 million per year. If question 2 passes, it will give insurers incentive to deny coverage for health care that would extend life and to opt instead to cover the suicide option, which is the far cheaper way to go. And in fact, this has happened in Oregon with a woman by the name of Barbara Wagner. She was 74 years old. She had 4th stage lung cancer. She was prescribed by her doctor a drug that would have extended her life, and that was what she wanted to have as a medical treatment. She applied to the Oregon public health insurer who insured her for coverage of this drug. The insurer wrote back and said they would not cover the drug, which was quite costly, but it would pay for her to buy the suicide pills, which were a matter of about $100. There was she brought this to the attention of the press, the media in Oregon. It created such a public relations storm that the insurer didn't back down, but the manufacturer of the drug stepped up. It was Genentech, and provided the drug to her for free of charge, and Mrs. Wagner lived another 2.5 years. So this is an absolute reality in the world we have today. And when you mix health care cost pressure containment with the suicide option, it's a deadly mix. And we can't rely on insurers to do the right thing versus the cheap thing. So this is another concern about what it would mean to have this proposal enacted in Massachusetts.
That's scary.
It is scary. And while we've been talking about this this option, the suicide option, one of the points I also wanted to make was that I think there's probably a common misconception out there that people may have, that this process of the suicide is simply a matter of someone taking a couple of pills and lying back gently on a pillow and painlessly and effortlessly slipping away, when nothing could be further from the truth. In fact, the dose, I've brought an exemplar of what the dose is for the lethal drug. It is 100 capsules. These capsules are empty. This is just an exemplar. But these are 100 capsules of a drug called seconal or secobarbital. And I'll just put it out here for the viewers to get a better look at it. And the dose that's necessary is to consume the entire quantity of the drug that is contained in these capsules all at once, which means that every capsule has to be opened, the drug has to be deposited into something like applesauce or a liquid or some kind of juice that the patient can then consume very quickly all at once. The side effects for this drug include vomiting, which is for which it's necessary to take a second drug, a prescription drug that the doctor would have to give the patient, and seizures. Death can take 3 or more hours to occur, and despite the risk of complications and the duration of potential for the death to occur, there's no requirement in this law for a doctor to be present with the patient at the time of death. Now, in Oregon, it's again back to their public records of the Public Health Department, have shown that in from 2008 to 2011, in only 7% of cases was there a doctor present at the death of the patient. That means 93% of the time that patient was not attended by a doctor and when they took their own life. And it shows you that if it's not required in the statute, doctors are not going to be there. The other thing that's not mentioned in the statute is a requirement for the patient to have any kind of mental health evaluation before they take this last and final step. Consider, if you will, that perhaps a passage of 2.5 or 3 years has gone by since the patient got the prescription, and the meds have been sitting in the medicine cabinet for all that time. Well, maybe the patient, when they first got this prescription, was sufficiently clear-headed to make this choice. Maybe not, because they may never have had a psychiatric evaluation. But consider the passage of time, and the question arises, has the patient's mental state changed? Have they now developed a more confused judgment? Have they developed dementia? Are they under some kind of influence now that's compelling them to make this decision now, that they've now waited 2 or 3 years? Why now? And without, again, a professional to intervene at that stage to determine whether, in fact, the patient is truly acting of their own free will, you have a serious potential for abuse and for people taking this drug, or perhaps being forced to take the drug against their will, and without any kind of intervention, you're having people who may be dying needlessly. Lastly, not only is there no requirement for a doctor to be present or for a psychiatric evaluation, there's not even a requirement for a witness to be present at the time of the patient's death. And this to me is most concerning, because you are opening the door for abuse of people who are perhaps elderly, seriously ill, dependent, trusting on people to act in their own best interests. And we all know this is not a perfect world. There are people who are unscrupulous, who act selfishly, who make terrible choices for their own self-interest and that hurt other people. Elder abuse has been on the rise in Massachusetts for 3 years, from 2008 to 2011. Elder abuse was on the increase 31% in Massachusetts. Without anyone to observe this death, this statute would facilitate a policy where we are intentionally ending human life in secret. And I think people have to decide whether, in fact, that really is a safe and necessary policy for this state to be implementing and facilitating. And the reason also that there would be a danger in the absence of a witness is that the death certificate, by virtue of the way this statute is written, the death certificate will report that the cause of death was the natural underlying disease, not that this was a death by suicide.
So that would mean that the insurance company, if they're insured, will not have to pay any life insurance.
No, to the contrary, because the statute makes a specific provision that any insurance or a contract or other agreement that's in effect at the time that this takes place, and any that's entered after this law becomes a law, that would be January 1st of 2013, will not be affected by this law. So that means that life insurers will have to pay on policies for people who opt to kill themselves, because the death certificate is going to say the cause of death was their disease. So there's not going to be any basis for insurers, number one, to deny coverage, but more to the point, the statute specifically prohibits them from denying coverage. But the other significance of the death certificate falsely reporting the cause of death is that in Massachusetts, the medical examiner is the person to whom there is a duty to report deaths by suicide. And the reason for that is to allow the medical examiner to conduct an investigation of the death. If the death is reported as natural, not suicide, there's no basis for a report to the medical examiner, and then there's no basis for him to investigate these deaths. So you have death in secret that will not be investigated. There's nothing in this proposed law that gives the Commonwealth of Massachusetts any right or authority to investigate the deaths under this act, which in itself is another area for great concern. In addition, the report of any information about this death is essentially one that is voluntary by the doctors who treat this patient. And the reason for that is that the statute provides that the Department of Public Health is to decide what kind of information they want to gather about these deaths, what kind of information do they want to know about the patient who chose this option. And then they are to ask the doctor to provide that information to them after the patient dies. Maybe the patient's name and what the disease was and how long it was before, from the time they took the prescription until they took the pills. I'm just guessing, but that would be kind of the statistical information I imagine they would want to acquire. However, the statute also says if the doctor doesn't provide this to the public health department within 30 days of its request, what the public health department should do is ask for the doctor to do it again. There's no penalty provided for in the statute to compel doctors to comply with this request for reporting. So there's nothing to pressure or push doctors to comply with this request to provide information. Now, as I said earlier, this is the same statute that's in effect in Oregon. And I would point out that any data that you hear about Oregon, even the numbers that I've quoted today, you have to take with a grain of salt because we have no way of knowing how complete that information is. Because there's virtually a voluntary information reporting requirement in Oregon, we have no way to know how many instances have occurred that have not been documented and for which there are simply no records. There's nothing to penalize doctors who choose not to make those reports. So if there's abuses, they will be unknown. If there is any kind of misbehavior with respect to how these drugs are handled, we will not know about them. If there's people who've been tricked into taking them, we will not know about them. And I suggest that that is a very dangerous situation for the welfare of the people of Massachusetts.
I agree. That sounds really, really frightening.
Now, you asked me also previously about the issue of choice, which I mentioned had to do with your insurance company ultimately having the choice about whether you get treatment or whether you take the suicide option. The other aspect of choice that the supporters promote is that there be, this is something that patients have the right to decide for themselves, that they have a right to end their suffering in the last stages of their life. However, they also talk about ending pain, ending suffering as the motivation and the purpose for enacting this proposal. In fact, pain is not the reason most people even think about suicide, and this too has been documented in studies. Today, as I said earlier, most of the time suicidal requests stem from depression, a treatable condition, and which if people are treated for, most people change their mind and don't want to die. And in fact, medical science today has the ability to prevent anyone from suffering uncontrolled pain. Hospice and palliative care people tell me that if a patient is in that kind of pain, they should be getting another doctor because there's no excuse or reason for it today. Medical science can keep people from suffering this kind of pain. In the information booklet for voters that was sent out in Massachusetts, there is a summary from a woman as a supporter, and there's someone who's an opponent to this question too. And the supporter is a woman by the name of Heather Klisch, who tells the story of her father, who was in the last days of his life, who wanted to take advantage of the Oregon suicide option. So the family flew out to Oregon, got him settled out there, and she paints a very I call fairy tale kind of picture about the last hours of his life, with the family gathered around him, and it was all very peaceful, and they thought it was just wonderful. And I have to say, I'm pleased that this worked out for the Clish family. However, I think that what is important to think about is the reality that we do not live in a perfect world, and that what might look good on paper oftentimes is not what is put into practice, and that there are many, many people who are vulnerable, who are exposed to abuses by virtue of the way this proposal is written. In my view, this is not a question of curbing or of denying someone the choice, that it's more a situation in which it's something that we do in society oftentimes, when we limit the options or the behavior of a few in order to protect the welfare of the many. That's what non-smoking laws do. That's what leash laws do for dog owners who can't just let their dogs run freely. We make a choice as a society to protect the many because it's too dangerous a situation for their welfare to allow the few who may want to take a different road to have that option. And I think this is the kind of a balance and a weighing of factors that people should consider when they decide how they feel about question 2 and the doctor prescribed suicide option. The last thing I would say is that this is not a question of patient rights. The president of Compassion and Choice, a woman by the name of Barbara Coombs Lee, testified in 1996 that before a U.S. House of Representatives committee that was studying assisted suicide. She testified that this proposal is not about patient rights. It's about giving immunity to doctors. And in fact, she got that right, because patients today have the absolute right, and have for decades in Massachusetts, have had the absolute right to control their health care, to accept or to refuse treatment, to discontinue treatment at any point in time. Any patient today can go into their doctor's office and request a prescription for a life-ending drug. They probably won't get it. But this law only doesn't give the patient any new rights. They can go in and ask for the prescription. What this law would do is to protect doctors who say, okay, I'll write that prescription for you. Protects them from any legal consequences of their action in writing that prescription. In fact, it's important to also note there's nothing in this law that requires the doctor who's treating the patient to actually be the doctor who writes the prescription. That means that a doctor who knows this patient, who's been taking care of the patient, who determines that, no, I don't think you should be taking this, or I just don't want to write this, because doctor's participation is voluntary. That doesn't mean the patient's not going to get the prescription, because the patient can take his or her diagnosis in her medical record as having a terminal illness and take it to some other doctor who may be a complete stranger to the patient, but somebody who is willing to write the prescription, and the patient can eventually get the prescription filled. So there are many, many things in this law, as I said, that have cause for concern. Mm-hmm. Oregon has had 15 years experience with this law. I don't know why they wrote it the way they did. They could have changed it, at least to address even the issues that I've brought up. And I could go on for quite a bit longer pointing out things in this proposal that are problematic. They could have changed at least these things, tightened it up, really tightened up and protected people from the obvious potential for abuses, and they haven't. And I think you have to ask yourself, why haven't they? I can only conclude they haven't because it's the way they want it to be written.
I don't like the sounds of it. It's kind of scary.
Well, it is, and you know, the supporters say that those who are opposed to this question 2 are trying to scare people, mm-hmm. are painting a very bleak picture. I would submit that this is a scary subject. Mm-hmm. Suicide is a scary subject. dealing with the reality of suicide is not a fairy tale. And the realities are potentially very dangerous. Speaking the truth, the unvarnished truth, not in euphemisms, not pretending that things will be just perfect, does create a reality that is scary without need for any kind of hyperbole or exaggeration. The reality is scary. It's interesting to note that in the 10 pages of this law, the one word that is never mentioned is suicide. They speak of a death with dignity. They speak about a self-administered medication. Medication is something that heals. This is not medication. These 100 capsules are poison. That's the reality. And I don't think speaking in euphemism serves anyone's interest. The people who I've been working with try to tell the truth to people so they can make an informed decision about what this law would mean for them, for generations to come, and for the welfare of the people of the Commonwealth of Massachusetts.
Well, I agree. It should go away. We shouldn't have it. I agree with you there. Not as the director of the Council on Aging, but as the person.
Yeah.
If you know what I mean.
Yeah.
So does anyone have any questions regarding this?
I have a question.
Yes.
I understand what you're saying about the statistics not being accurate because it's voluntary. Does Oregon present any numbers as to how many people have asked for this drug and how many people have followed through and what the results of the following through has meant?
Well, the most recent numbers I've seen for the total number of people who have availed themselves of this option over the first 14 years this was implemented in Oregon are 596 that have been reported. Now, that number, as a percentage of the population of Oregon, which is 3.8 million, if it were applied to the percentage of population, an equivalent percentage of population in Massachusetts, would translate to 1,011 people. I would also point out that the Oregon's general rate of suicide has soared since this proposal became law in Oregon. As of 2010, Oregon's suicide rate is 35% higher than the national average. General suicides, not including the doctor-prescribed situation, because after all, that's not suicide. It's not counted as suicide.
Right.
So the general suicide rate has gone up quite a bit, even although it had been going down in the 1990s. And this was enacted in 1997, October. I think it became law in 1998. So for those 14 years after that, once we hit 2000, their suicide rate started to climb.
Is there some suggestion that it's related to this law?
Well, studies have shown there is such a thing as suicide contagion, which is what happens when you normalize suicide in one area, in one defined group. It does have a tendency to change people's attitudes about suicide in other areas. And over time, people get deadened to the idea that suicide is not a good idea, that it's bad. Somehow it's acceptable, becomes more acceptable, and it seeps into other areas of society. And that's just something that is a phenomenon that has been studied and is documented. And it's a risk, again, to the welfare of society as a whole, that once you start saying, this life for this person really isn't a problem. If they want to kill themselves, that's okay. But everybody else, we care. We don't want you to commit suicide. We don't want you jumping off of bridges. We're trying to keep kids from committing suicide with drugs. Well, eventually those arguments start to break down because they say, well, if it's okay for this group, well, maybe it's okay for that group too. And you start increasing the number of exceptions. And again, all of this feeds into people's perception of the idea of suicide. And it changes people's attitudes, not in a good way.
How do you address the people who want choice? What is this group that you represent? What do they say to the people that are actually feel that they are suffering and that they do want to take their own lives? Would the adjustment of what you feel is wrong with this bill, would then that make the bill more palatable? Would it make it something that would be more acceptable to this group?
In terms of, I can speak to is what's written on these pages that the voters are going to have before them November 6th. This proposal as written is not the way to go, regardless of what anybody thinks about the pros, the advantages or disadvantages to doctor-prescribed suicide. This 10-page proposal is full of potential problems, and that's all I can really speak to right now. But in terms of the issue of choice, as I said, we, as a society, decide that when there's a group of a few people, relatively speaking, who want to engage in a certain behavior, when we decide that that behavior for society as a whole is harmful, we put limits on that group that wants to participate in that behavior. An example, as I say, is for smokers. We have non-smoking laws because we have found that for the society as a whole, inhaling secondhand smoke is a bad thing. So we limit what smokers can do. And in my mind, this suicide option for those people who may feel they want to take advantage of it presents such a risk to the rest of society of danger and problems that it's not worth allowing them to take this option in the way this statute is written right now.
Okay, thank you.
You're welcome.
Any other questions?
I'll volunteer one question I'm often asked, and that is, what happens to these pills once they're in the possession of the patient? Who has charge of them, and whose responsibility is it to control them and dispose of them? And that's another area where the statute is completely unhelpful. It makes no provision for how these pills are to be preserved, where they're to be kept. The only thing it says is that any unused medication, they call it medication, has to be disposed of according to law. But they don't give you any guidelines or particulars for how you accomplish that. It doesn't have any time frame within which the pills have to either be taken or discarded. It doesn't have any guides for the kind of security that these pills should be kept in to keep them out of the hands of kids, people who are looking to make a quick hit and sell them on the black market, find them in somebody's medicine cabinet, and help themselves to them. Potentially someone who would take them in error. And if they're not completely used, what do you do with them? And there's nothing in the statute to help with that, which is a whole other area of exposure of harm to a whole other sector of people. The young, the foolish, who knows who might have access to these pills sitting in somebody's medicine cabinet for 2, 3, or longer years. So that's a whole other area of concern.
Who pays for those pills? Insurance companies?
Well, the insurer would pay for,
Oh, that's just
assuming the person had coverage, the insurer would pay, they're only $125
Yeah.
for the prescription. It's a
That's all.
one-time prescription. That's why the incentive is there for insurers to deny you coverage for life-extending treatment, which very well may be far more expensive. But they're under now this pressure to cut costs for health care. This is virtually a license for insurers to say, we're not going to pay for the medical treatment like they did for Mrs. Wagner in Oregon, but we'll pay for the pills.
That's interesting.
John, did you have a question?
I do. As a primary doctor, is there anything, any recourse that a patient would have against their primary if they suggested or didn't want to fulfill this prescription? I know you said that they could go to someone else and that their primary doesn't have to be the one, but I mean, does this law have a provision that maybe the doctor will say, well, I don't want to take the liability, so this person wants, I'm just going to give it to them?
I'm just going to give it, no. I mean, the doctor, I'm not sure I completely understand your question, but the doctor's participation is voluntary. So a doctor can absolutely determine that he or she does not want to write this prescription at all for anybody or at all for this patient.
And the patient has no recourse against their
No.
doctor, so the doctor wouldn't feel compelled to
No.
have to
No.
agree to this request.
They would not, but I should point out the American Medical Association and the Massachusetts Medical Society are both opposed to doctor-prescribed suicide, as are all the disability rights groups. This group that I work with is really a coalition of various kinds of groups who are concerned about this: medical, elderly services, disability groups. And the disabled particularly are concerned because they feel already that people put a lesser value on their lives because of their disability or their handicap. They don't feel that way about themselves, but that's how others view them. And they're concerned that this option will be something that will be foisted on the disability community much more readily than the regular non-disabled community. And they see this as a terrible threat to their own welfare, and they're very much against it.
Well, as far as I can see, you were most helpful in helping people make their decision and which way to go.
Well, thank you, Mary. I can't tell anybody how to vote, but I would hope that they would consider carefully whether this proposal is wise, whether it's safe, and whether it's really necessary for Massachusetts before they make that vote on November 6th.
I certainly hope that they rethink their decisions if they were going to vote yes on it, because it doesn't seem like a healthy thing to do. And as far as I can see, many doctors have taken the Hippocratic Oath, so it's a matter of conscience with them. And I'm seeing the ads on television, too, from various pharmacies who refuse to participate in it. They will not fill the prescription. So that was their view.
Well, yeah, pharmacies, I don't know if they have the option not to. I think doctors have absolutely the option not to write these prescriptions. But for a pharmacy, I'm not so sure. I think they're pretty much would have to fill the prescription, but they're not pleased by the idea of it because, again, their business is helping, healing, curing people, just as the doctor's Hippocratic Oath is about healing. Doctors take that very seriously, and so do pharmacists. In their business, it's about healing and helping people with medicine, not with poison, and that's what this is. This is poison.
Poison. It sounds like a horrible way to go.
Well, it's certainly not a painless death with dignity, in my view. But again, it's a matter of euphemism that is used in the statute, a lot of soft-sounding, comforting words that disguise the reality of things, and that's what people have to think about with a clear head about what would this really mean once it's implemented and once it became the law in this state, and what might it mean to me in my life 10 or 15 or 20 years from now, because we will all be affected by it in one way or another.
That's true. And so as Massachusetts goes, so does the whole country go, and this is not a good way for the country to go or for Massachusetts to go, in my personal opinion. Well, thank you for being with us today.
It's my pleasure. Thank you so much for having me.
And thank you at home for being with us.